Yeah. We're starting a Rambam, sure. I'll send you something different. I want to hear what happened with your meeting.
Rambam.
Okay, hello, Stephen.
Hello, everybody. I don't know what's going on with my screen. It's intermittent. This comes and goes. Sorry, let me just put in the text.
Yeah, that looks better.
I'm sure it'll happen again lately. I don't know what's going on. Okay. All right. Goes on and off. I'm sorry. Maybe I should just close it.
Yeah, I think that usually helps. If you close it and reopen.
We'll see what happens. If it carries on, I'll close it. Okay, I have a rabbinical meeting at 1 o'clock. I said I'll be late, so let's get started. Hello, everybody. I hope you're having a good week.
Yes, thanks.
Next week I'll be in Cape Town, but I hope to be able to do it still. Please God. Okay, so we are continuing with the laws of Edus, of witnesses, chapter 15. So you've been through quite a bit already. I did witnesses last week, so just give me 1 second. Okay. So basically we're dealing with different situations of conflict of interest, which would prevent a person from being a witness. So basically the opening halacha aleph is kol edus shetovay hano le'odam mimeno einoi meyed ba. Any testimony that will benefit the individual who is giving such testimony, he may not testify, because it's as if he is testifying concerning himself, and he is biased in favor of himself, obviously. So if he will derive a loss or a benefit, depending on how this court case goes, he may not be a witness because there's a bias here and there's a conflict of interest, and he may just be giving testimony to suit his own situation. So he loses his objectivity and he loses his right to be a witness. And we'll have a whole series of situations where there is different forms of conflict of interest. So, therefore, when a person comes to the inhabitants of a city with a complaint concerning the public bathhouse, for example, or thoroughfare, the public thoroughfare, none of the inhabitants of the city can testify regarding this matter, nor serve as a judge, neither a witness nor a judge, until they undertake a contractual act removing themselves from any connection to the property in question. Afterwards, they may serve as a judge or a witness. So it's not like today where you have the municipalities are in charge of enlarging the potholes or whatever it is. So it's the citizens against the municipality. In the olden days, the citizens were the municipality. It was a communal responsibility of all the citizens of the town. So let me just get rid of this call, sorry. put it on silent before. Give me a moment. Let me do that now. Okay. Sorry about that. Okay. So because all citizens are stakeholders and committee members, so to speak, of the management of the city. Therefore, if a guy's going to testify, be a judge, it can cost him. He may have to pay. He may have to repair the bathhouse or fix the potholes. And it may cost him. He's part of the body corporate, so to speak. So therefore, he loses his objectivity and he cannot be a witness or a judge. 2, following rules apply when a communal Torah scroll is, God forbid, stolen, which has unfortunately happened. There are Israeli mafiosos who know how to get into shuls. That's why in recent years, most responsibly run shuls have turned their Aron Kodesh into a vault of sorts with sliding security gates or other forms of security measures to prevent Torahs being stolen. A Torah is a very expensive object today. You can pay $50,000, $40,000 for a Torah. You're not going to get the cheapest, low quality Torah. I don't think you'll get under $30,000. So what's that? Over $500,000 rand. That's a lot of money. So if God forbid a Sefer Torah is stolen, since it is intended to be listened to, the reading of the Torah is intended to be listened to by all the members of the community, it is impossible for a person to withdraw his share of ownership from it. He can't say, okay, I'm contractually signing myself out. I have nothing to do with the Torah. What do you mean? You're not going to come to shul? You're signing a contract that you're not going to come to shul? You're never going to hear the Torah? You're a beneficiary of the Torah reading. You should still come to shul, even if you're not a gabbai. Hence, the matter should not be adjudicated by the judges of the city, and the inhabitants of the city may not testify to prove the city's ownership. Like, yeah, they find the guy, they find the Torah, and now you have to prove that this is your Torah. It's not his, it's yours, and he stole it. So again, because you are a beneficiary of that Torah, so you are somewhat biased. So what do you have to do? You have to go to a Beth Din of the next town, obviously. 3, the person says, give a mana. A mana is a certain amount of money, say 100 rand, to the poor people of my city. The matter may not be adjudicated by the judges of that city, and the inhabitants of the city may not testify to prove that the pledge was made. Maybe the guy made a pledge, and then he wants to renege on his pledge. So we need witnesses to say that he made a pledge. It's his code of honor. He has to keep it. Because in Torah law, a word is a bond. And a verbal agreement, a verbal contract is binding. So, but he says here that the cities, the residents of the city have a problem. When the poor people depend upon them and they allocate charity to them. In such a situation, even if 2 members of the city promised, we will give the fixed amount required of us regardless, let us testify, meaning we're not here to save ourselves money. If everybody has to give X amount to make good this donation, which this guy is absconding from, and they say, no problem, we'll give our donation and we'll be happy to testify. We still don't listen to them, and they're considered subjective rather than objective, because they receive benefit from the fact that these poor people become wealthier, for the poor are dependent on the inhabitants of the city, and similar is applied to all analogous situations. So even if they don't have to, even if they're going to pay their way anyway, it's in their interests that the poor people of the town should be made better off by this pledge, because it'll help the town on many ways. The poor will be able to pay their own city dues. So therefore, they are considered biased. 4, when a person raises a protest and seeks to expropriate land with compensation or without compensation. So we're not talking about expropriation without compensation. We're talking here about someone who raises a protest and seeks to expropriate land that is owned by 2 partners, and he says the one partner owes him money, and he's not paying. So he has a right to claim the debt from the person's property. That's the halacha. Now, this particular property is owned jointly by 2 partners. One of them is his debtor, but not the other. So if somebody says, this guy owes me money, he's not paying, and I want to expropriate land from this field or this property where he is a 50% partner, the other partner of the other 50% may not testify on behalf of his partner concerning the land unless he withdraws from ownership of the land first and undertakes an act of contract affirming that he gave his portion to his partner and committing himself to reimburse him for its value if his own creditor expropriates it from his partner. Only after undertaking such an agreement may he testify. So clearly, if the guy takes away the land, the partner is going to be affected negatively. And it's complicated. Even if he doesn't take away his 50%, but suddenly he's got a new partner and so all kinds of things. So we assume that the partner will have a self-interest in keeping his original partner. And therefore, unless he extracts himself from this partnership and this relationship, he will not be allowed to testify. 5, the person protests the ownership of a field if it contains produce, not just property, but there's a whole acre of mealies growing there. A sharecropper may not testify with regard to it. So the sharecropper is the guy who works the field, sows and plows and harvests. And the way the sharecropper system worked in the old days, you probably learned it in the past, somebody owned the field. He was like the silent partner who put in the money. And somebody was the active partner. He worked the field. So the guy with the money who owned the property, he sat at home doing whatever he did. Played the market. I don't know what he did. The sharecropper is the guy who works the field, and then they split the profits. That's how it worked. In different communities, it was 50-50, 60-40, 70-30, whatever. All subject to negotiation. But if someone is claiming that the owner owes him money and he's not paying, and I want to expropriate this land, and this land has an acre of mealies growing, the sharecropper who planted those mealies and is going to get a share of those mealies when they're harvested may not testify with regard to it, for the sharecropper will naturally want it to remain in the possession of the original owner, so he'll get his percentage of the crop. However, if there's no produce in the field, so the sharecropper has no real interest, then he may testify. What about if somebody is renting a property and someone comes and wants to take it away? It's not his property. He's just renting it. Different rules will apply. If he brings the rent with him and says, let whoever the court establishes as the right owner of this field, here's my rent. Makes no difference to me who the owner is. You guys fight it out in court. I'm paying the rent. Here's the rent. The Beis Din will say who could take it. So he's not involved. In such a case, he may testify. However, if he already paid the rent to the original owner of the field, he may not testify. Because if the field will then be expropriated from him and given to the other guy, then this renter may have to wind up paying rent for all the years he dwelled in it to the new owner who says, listen, you didn't pay me. This has been my land for the last 10 years and you've been living here, and I insist on you paying me 10 years worth of rent. So how can he testify? He's negated, he's biased. 6, if Shimon borrowed money and Ruvain guaranteed the debt. You know, you go to the Rambam Trust. We have here a big interest-free Jewish loan society. You could borrow 20,000 rand or maybe even more, and they want you to get guarantors. They want you to get people to sign security for you. So if Shimon borrowed money, and Ruvain pledged security guaranteeing the debt, that if Shimon defaults, you can come to me, I'll pay. Yehuda entered into litigation against Shimon, who was the borrower, and sought to expropriate landed property from his possession. If Shimon possesses another field equal in value to the debt guaranteed by Ruvain, then Ruvain may testify with regard to the land, asserting that it belongs to Shimon, because he does not derive any benefit from this. For even if Yehuda would expropriate the land, Shimon possesses another field from which the creditor would derive payment, so it's not going to cost him any money. But if Shimon did not have other property, the only property Shimon's creditor could come and attach would be Ruvain's, because Ruvain was the guarantor. Then he may not testify because he's biased. He may lose his field. Similarly, a person who purchased the field may testify on behalf of another person who purchased the field from the same seller and affirm that the field is his, because it doesn't affect him in any way. This applies provided the seller owns a field that is not on lien, that is equivalent to the value of the field acquired by the first purchaser. In such a situation, the first purchaser does not derive any benefit from the field remaining in the possession of the second purchaser, for even if the field he purchased is expropriated from him, he may seek reimbursement from the seller, and the seller possesses another field from which he can expropriate his due. So if the guy has land from which the first guy can claim, so then he can be objective. But if not, then he may lose his field, and he's definitely not going to be objective. Quiz questions. Number 1, may a person testify about his business partner who is being brought to court by somebody else? We had that in the beginning.
Number 2.
Number 2 is correct. Thank you, David. He had to remove himself from the partnership. He had to sell it or give it away, so he's not going to benefit one way or the other. 2, if a person guaranteed a loan for someone, can he testify on behalf of that person when a creditor of his takes him to court?
No.
Well, there is not an option of no. It's either yes or not, unless the borrower has land in his possession that is as valuable as the debt he owes.
No,
Which is what you mean, right?
Yeah, of course.
I thought that's what you meant.
Yeah.
May the city's judges adjudicate how money that was donated should be given to the poor people that rely on them?
No.
No.
Because they are going to be affected. So we'd have to go to another Beth Din. And finally, why is a person forbidden to testify about something that he will derive benefit from? That should be pretty obvious.
Number 1.
Number 1 is correct. Thank you, guys. Have a wonderful day, a wonderful rest of the week. And we will, please God, hopefully see you next week as well.
Thanks, everyone. Cheers, everyone.
God bless. God bless.